Boker Tov. Today's Daf Yomi is Bava Metzia Daf Zayin, Bava Metzia 7. And we are continuing along this beautiful Masechta. Thank you, Hashem, for the opportunity to study. We're studying in the merit for Am Yisrael to have a Yeshua, for there to be a Shmira for the Chayalim, and a Hatzalah for the Shvuyim. We're going to start on the top of 7a. 4 lines from the top, that Amrei Ravacha Midifta Ravina, Ravacha Midifta says to Ravina that it had said in the Bryce on the previous page that if there was a suffix that hold on. That we said that if there was a suffix, if we're not sure if the animal was a firstborn or not, that the Brisa Sveikos, that if they are, if we're not sure if it was a firstborn, and then they entered into the deer, and then they entered into the corral together. So that is what the Bryce refers to. And the Bryce, let me just say the exact language of the Bryce. Bryce says that even though these are animals that are suffix firstborn, we're not sure if they're firstborn, they can enter into the corral to tithe. Good Boker Tov, guy. We're on page 7a. 7a, 3 lines from the top. Ramier, this is my dear friend Guy. He's a very good person. We're very honored, and we feel privileged to be able to study with you every day, Guy. And you're sitting next to a war veteran.
A married man.
Okay, we have it. You have it already. I put you in. I gave him one. Okay, so it says here as follows. It says that if there was that Ravacha Midifta Arvina says, what does it mean that when we say that the Sveikos, that these animals that worked out whether or not they're firstborn, that they can enter into the corral? What is it referring to? Ilema suffix Bechoros. If you want to say, well, it literally refers to an animal. We're not sure if it was an actual firstborn or not. Well, we wouldn't tithe such an animal because the pasuk says, the pasuk says about the tithing, Kodesh Hashem, that after you tithe, that it will be holy. And that comes to mean Amarachman Velo Shekvar Kadosh. It means not if it was already holy. So if it was already holy, then it can't be tithed. So if it was a firstborn animal, it's already holy. So it must mean El Safik Pidyon Pater Chamar. It must be referring to a case where we're not sure if a donkey was the firstborn male. And then it's like Rav Nachman. That Rav Nachman taught, what do you do in a situation where you have a donkey and you're not sure if it was the firstborn? Rav Nachman taught in the name of Rabba Barvua, Yisrael Sheyesho Asara Safik Pitrei Chamor, that if you have 10 donkeys and you're not sure if they're firstborn or not, B'toch Beis, so and they're in your house, what do you do? Mafresh Alein Asar Siyan. You separate 10 lambs, Uma'asrin, and then those are the ones that you take into the corral and you tithe them. Hein Shalo. But since you're not sure if it really needs to be tithed, you get to keep them. But that's how you redeem the firstborn donkey. So we had discussed yesterday, we had discussed the case in the Masuta where there were two people fighting over a bathhouse, and one of them said it's mine, and the other one said it's mine, and then one of them consecrated, and then the rabbis weren't sure if it was really consecrated. So they stopped using it. Then they said, "Go ask the question." So they went. So what happened in the end? What happened to this bathhouse? Tashma Dam So there was an incident in the house of Rav Chisda, Rav Chisda Bei Rav Huna, and Rav Chisda in the house of Rav Huna, Upashta. And they answered the question, Mehadar Amar Rav Nachman. The Rav Nachman taught, Kol mamon she'ein yachol otzil b'dayanin, any money that you can't, that a judge isn't going to rule that we're going to take the money away from you, hiktisho eino kadosh, that if you consecrate it, it's not consecrated. So anyway, we see from here, this answers our question, because since the judge couldn't figure out whose money it is, he wouldn't have been able to consecrate it. So the bathhouse is not consecrated. But the Gemara says, well, wait, let's analyze the statement of Rav Nachman. Does that imply that if you are indeed able to consecrate it, hikdisho is kadosh, that if you are indeed able to consecrate it, that you can consecrate it, even though you don't even though the court has not yet taken the money away. How could that be? Rabbi Yochanan told a gezel b'lonis yashu about him. Let's say somebody stole something and the owners didn't give up hope for it. Shneim en yecholin lachtisho. Neither of them are able to consecrate it. Zelafisha eno shelo, that the robber can't consecrate it because he doesn't own it. He stole it, so he hasn't acquired it. Zelafisha eno birushuso, and the person who was robbed can't consecrate it because it's not in his possession. So how can you consecrate what the court is going to eventually give to you if it's not yet in your possession? Gemara says, no, what are you talking about? Misavris b'mesuta b'metalton. And you think we're talking about a bath that they sell that's like a movable bath, a portable bath. That's not what we're talking about. The Mesuta Mikarkaya, no, we're talking about a case where the bathhouse was attached to the ground. And so therefore, since it's attached to the ground, it's considered real estate. And since it's real estate, that therefore the then when the court gives it back to you, it's going to be considered as though it was always in your possession, because real estate can't be stolen, and so therefore it's in your possession right now, and so therefore you could consecrate it. If in the future the court is going to give it back to you, since it's real estate, you can consecrate it right now. So now we go back to our case that we've been discussing for the first 6 pages of Bava Metzia, that 2 people are grabbing a holding of a talus. So now we say as follows: Tani Rav Tachlifa bar Marava kameid Rabbi Avo Shnayim madukim v'talus. Let's say 2 people are holding onto this cloak. It says Rav Tachlifa bar Marava, means he's from Eretz Yisrael. Said in front of Rabbi Avo, Zeno to ad makom sheyadu magas, v'zeno to ad makom sheyadu magas, v'ashar chokim b'shava. So basically, if they're holding on to a garment, each one takes completely the part up until where their hand is holding, and the rest, the part in between, that's what they split. So Machil Rabbi Avo demonstrated, he pointed ubeshvua, that they have to take an oath, taking an oath on the remaining part. So the Gemara says, well, okay, now we've established that they each get the part up until where their hand is holding, and the rest they split. Well, if that's the case, our Mishnah that we started back on 2a, Masnisin Dikatani Tepalgi Ba'adadi, our Mishnah, which says that they split it with each other. There, the Mishnah said about the 2 people holding a talus, each one splits it. That they Velokatani Zeno Makam Shiadu Magas, and it doesn't say that they get up until the part where their hand is holding. What's the case of our Mishnah? What's the case? So Amar Papa, the Tfisi Bekarkasha. Where are they splitting the whole thing? Where they're holding it just on the fringes. They're not holding the whole thing. And their hand isn't really on this part of it. They're just holding it on the fringes. So from the fact that we see that if you're holding on the fringes, that's considered like you still have a portion of it. So Amarav Mesharshia, Shma Mina, we learned from here, High Sudra, that if you have a handkerchief that you give over as part of, it's time to start coming in to sell the chametz, and you grab a hold of the rabbi's gartel, the rabbi picks up the gartel, or a handkerchief. This handkerchief, that once he takes hold of it, given the tafitz ba'sholosh al sholosh, once he holds 3 fingers by 3 fingers, Karinan Bay, we're going to say v'nasang l're'ayu. It's as though it was given over. To command the pasuk tami v'kani, it's as though he picked up the handkerchief and he's acquired the item. So you don't need to hold the whole thing. You just need to hold 3 fingers of it. So the Gemara says, but wait, is that really the case? We have a different teaching with respect to a get, a divorce, the document that a woman is given to divorce her. Then why is it different than the case here? We're saying you only need to hold 3 fingers, and it's like you've acquired it. Why is this different than the case of Rav Chisda? Rav Chisda get biyada. Let's say he gives her the get, he gives her the divorce, umashicha biyada, but he still holds a string to the divorce. If he's able to pick it up and bring it to him, she's not yet divorced. But if he's not able to do this, otherwise she is divorced. Meaning to say, in order to be divorced, he has to completely let go of the document. She has to have everything, not just 3 fingers. Gemara says, no, there's a fundamental distinction between the case of a divorce, giving a woman a divorce, and giving an object to a person. Also, when it comes to a divorce, the Torah uses the language of krisus, that he needs to completely cut her off. Krisus be'ina and voeka. He needs to completely cut her off, and if he doesn't do that, krisus be'ina and voeka. Hacha nesina be'ina. But here in this case, he just needs to give it to her. So by divorce, he needs to completely sever the relationship. So therefore, if he has a string attached to the document, she's not divorced. But in this case, he just has to give it to her. Mara says, Amarava, Imaisa Talis Museves. So Rava gives another case. Let's say the talus was gold. It had gold on it, gold strings or gold adornments. Then cholkin. Then we split it also. So pshita. Well, that's obvious. Why does Rava need to tell us this obvious law? We just said you split it. The Gemara says no. Tzricha dekai dahava Bava Metzia. Now we're talking about a case where the gold is in the middle. So that's what we're saying. You split it. The Gemara says, well, hanami pshita. Well, that's also obvious. So the Gemara says no. Tzricha the mikrav lagabe. Techad, where the gold is in the middle, but it's closer to one side. It's closer to one of the people. Mal detema, you might have said, you might have said, listen, if you divide it horizontally, the gold is entirely in my possession, so I should get all the gold. Kamash one, no, the other guy could say, why do you have to split it horizontally? Split it vertically, and then I would have my share. And he has a right to say that if they say you split it that way, then it's going to be split 50-50. That's a fairer way to split it, and that's the ruling of Rava. Ton Rabbanan, we move along and we say, okay, let's say people are not holding a garment, but let's say they're holding a contract, a note, an IOU note. Ton Rabbanan, Shnayim Adukim Bishtar. So the two people are holding onto a contract. Milva Omer Shalihu, the lender says, listen, this is my note. This is my IOU note that I had given, and now I want to come and claim it. V'nafal mimeni, and it fell off from me, umatzativ, and now it's found, and therefore at this point, he found it, but I want to collect it. V'lova Omer, and the borrower says, actually, the borrower says, no. What's going on here is shalchahu. You know what it is? It is your note. Bauer says it is your note. It is your note. Or some have the girsa that it was your note, that I really did borrow from you. However, afterwards, I paid this note and I returned to you, and you returned to me this contract, and it fell from me, and now it was found. So basically, the lender says it's mine. I never gave it back. You never paid it. And now it was found. And therefore, we're both holding it on at the same time. And the borrower says, no, it was yours, and I paid it to you. So therefore, I don't owe it to you anymore. So, Yiskayim Ashtar B'chosmav, Divrei Rebbe. We'll have to see what this means. But Rebbe says, you need to certify the contract. This is certification of contract is when the witnesses, the court signs that these are the witnesses. It's a process similar to notarizing a document. You have to make it an official document. Whereas Rabbi Shimon Gamliel says, Yachoku, that no, you don't certify the documents, you have to split it. We'll see what this means in the Gemara's explanation. Nafal Yadayin, and let's say it fell into the hands of the court, and we'll have to see what this means. Lo Yotziu Olamis. Then they never spend it, never take it out. And whereas the fourth opinion is Rabbi Yossi says, Harei b'cheskaso. It remains in its presumptive status. We'll have to see what Rabbi Yossi means. So let's now analyze this statement. The first statement is the position of Rebbe. Amar Mar Yiskayim Ashtar b'chosmav. That if the contract is certified, that you have to certify the contract. So the Gemara says, if that's the case, the Gabule Malve Kue, and if once he certifies the contract, you're going to allow the lender to collect the whole thing. But why? Doesn't Rebbe say, did our Mishnah say if two people hold something, you split it? So why is Rebbe going to say that if you can prove that this is a valid contract, he gets to collect everything? So he says, okay, this is how we have to understand the Brisa. It says Rava, in the name of Rav Nachman, bin Mikuyam, if the contract is certified, Divrei Hakol Yachoku. Both Rebbe and the Rabbanan will say that if the contract is certified, they'll split it. Because that's what our Mishnah is. Shnayim Ochsim Matalas. Ki Puigi, where do they argue? Bisha Eno Mikuyam, where we can't certify, where the contract was not certified. Rebbe Savar, Moda Bishtar, that if the borrower admits, yeah, this was a contract, Tzarach L'Kaimo. It's even though he admits that this was a document that he signed, that he agreed to, that he borrowed money, it still needs to be certified. The way, and if it'll be certified, Polig, then they'll split it. The way will Polig. But if he doesn't certify it, even though he admits that he borrowed this money, he's going to say, if it's not certified, we're not going to split it. Why? My time a chaspa. We're going to say the contract is worthless. Man Lova. Who is the one who gives us and tells us that this contract was in existence? The borrower. And Halka Amar de Paria. And he says, I paid it. So he's the one who said it, and he's the one who says, I paid it. I just want to stop for a second. Rebbe Elimelech says, no, what do we say? If you admit to a contract, you need to uphold it. Says Rebbe Elimelech, in me, it also can be read on a deeply spiritual level. That if somebody is moda, that the first step of a sin is admitting something, you need to admit your sin. But you need to uphold your words. You need to follow through on the confession that you did. So that's the first position. The position of Rebbe is, when do we say that you split it? Only if the contract is certified. But if the contract is not certified, then the borrower doesn't have to pay anything, and we believe him. Comes along Rabbi Shimon Gamliel's other position, Moda b'shtar shekosvo and ain't tzarich l'kaimo. Rabbi Shimon Gamliel says, if you admit to the contract, if the borrower admits to the contract, then it doesn't need to be certified. The afagav the lo mekayim way, and even though it's not certified, yachloko, then they'll split it. That's where Rabbi Shimon Gamliel says that you don't need to certify it, and if he admits to it, it splits. So that's the dispute. Comes, and then what's the next part of the price? So nafal yadayon, and if it fell into the hands of a court, will yotziu olamis? You never pay it. So the Gemara, meaning to say, it never gets paid. The court keeps hold of it. We're on top of 7b. We ask the Gemara, ma'ishnal yadayon. Why is it the case if it's in the hands of the court, it's never paid? But let's say, as opposed to somebody else, then what would be the law? So the Gemara explains, Amarava Hachakamar. No, this is how we have to read this brisa. If somebody else found the contract that had fallen into the hands of a judge, and what does it mean when we refer to a document that falls into the hands of a judge? What does that mean? The cause of a handpick, that the court wrote a handpick on it. What's a handpick? The handpick is a statement that the court certified this contract. So basically, if somebody else found the contract that was certified by a court, it's like again, similar to like official certification, a hempik, lo yotziu olamis. So then under those circumstances, if somebody else found this document that the court had certified, we still can't use it to collect ever until Elio comes or the witnesses say from whom it fell. Will only buy a low cost of bay hempik, not only if in a circumstance where there was no hempik, where there's no certification. Because there we could say cost of lova. That maybe he wrote that he was going to borrow, but never borrowed. Elafil cost of bay hempik. But even if there was a certification, and so we see that the contract was certified and that there actually was borrowed, and nevertheless, lo yachzir, nevertheless, that it should never be returned to the lender. Why? Because we have to be concerned. Yeah, there was a contract, but maybe it was paid, and that's why it's falling on the ground. And so that's what the price is saying, that if you have a contract that was certified, you never pay it. The Rabbi Yossi Omer, Rabbi Yossi say, Hareu b'chaskaso. Rabbi Yossi says, no, if you find this contract on the ground that was a hempik on it, we're going to assume it's a valid contract and you could collect the money. So the Rabbanan at this point say that if you find the contract with the hempik, you can't collect. And the Rabbi Yossi says you can. So the Gemara says, Rabbi Yossi is lo chayshino apiron. We don't assume it was paid. So we ask the Gemara, v'lo chayish Rabbi Yossi apiron. Is Rabbi Yossi not concerned that if you find the document, you have to be concerned it was paid? But don't we have the following brisa? Matzah shtar ksuva b'shuk. Let's say you find a ksuva. Ksuva is a bond that when a woman gets married, her husband gives her a bond, and he's going to pay this amount of money at the termination of the marriage. But you find this bond, basically this ksuva in the marketplace. So bizman shabal moda, if the husband admits that, listen, I owe the money, obviously yachzir isha, because nobody's arguing there. The husband says this is her bond, then you return to the woman. Ain't abal moda, but let's say the husband does not admit, lo yachzir, what was that? You don't return it not to the husband or to the wife, because we don't know if it was paid. Whereas Rabbi Yossi says Oda tachas bala. Well, if she's still married to her husband, then yachzir, because a woman would only collect the ksuba. First of all, she needs to have a ksuba, and second of all, she'd only collect it on the termination of the marriage. So if she's still married, obviously return it to her. But this armala on this garsha, but let's say she's widowed or divorced, well, yachzir, you don't return it to either one. So this contradicts what Rabbi Yossi said above, because Rabbi Yossi said above, we're not concerned it's paid, but here we have to be concerned it's paid, Rabbi Yossi says, and so therefore we don't return it to her to collect. So the Gemara says, Epoch. So we have this contradiction with Rabbi Yossi. So therefore, we have to reverse the positions in order to make it that Rabbi Yossi is not contradicting himself. And what do we say? And if it fell into the hands of the court, meaning to say that if it was in the hands of the court, you can never spend the money. Meaning, if it was certified, we always have to assume it was paid. That's what Rabbi Yossi says. Chachamim say it's a valid question. So therefore, we're saying Rabbi Yossi says we always have to be concerned that it was paid, and therefore you don't return it. So the Gemara says, so now we have a contradiction. We solved the problem with Rabbi Yossi. The Rabbi Yossi says we're always concerned with paid, but now we have a problem with Rabbanan. Then in the first case, the Rabbanan are now saying you don't have to be concerned that it's paid. Whereas in the case of the ksuba, we're going to say you can return it. According to this case now, the Rabbanan are saying, Kasha the Rabbanan. Now we have a contradiction between the Rabbanan and the Rabbanan. Because in the first price, with respect to the contract that fell into the hands of a judge, the Chachamim are saying, you don't have to be concerned that it's paid. Only Rabbi Yossi is saying now, whereas in the case you find the ksuva, they're saying that if the husband, that they shouldn't return it when the husband says that he paid it, because we're concerned about his words. Whereas in the first case, we're not concerned. So the Gemara says, okay, shtar ksuva kula Rabbi Yossi. So the Gemara says, okay, this whole brisa about the ksuva, we're going to say is actually just the position of Rabbi Yossi. The brisa was missing some words. We have to supplement. We're basically changing the way we read that brisa. This is how we read that brisa. That if the husband does not admit that this is his ksuva, you don't return it. When do we say if the husband doesn't admit, you don't return it? Where the woman is not married anymore, she's widowed or divorced. But if she's still married, you return it. Because Rabbi Yossi's other position, if she's still married, you return it. But if she's widowed or divorced, you don't return it. What was that? Not to either one, because we have to be concerned it was paid. So in the end, we're saying Rabbi Yossi says we have to be concerned it was paid, and the Rabbanan say we don't have to be concerned it was paid. Rav Papa says no. No, in the end, don't reverse it. Rabbi Yossi's position is that the contract is still valid and you can collect it. And when Rabbi Yossi says by the ksuba that you have to be concerned it was paid, he was only speaking according to the position of the Rabbanan. The Rabbanan Kamar. He wasn't saying his own opinion, he was speaking according to the position of the rabbis. He's saying, he says, according to me, even if she was widowed or divorced, we don't have to be concerned it was paid, and she can collect from it. But according to you who say that we have to be concerned it was paid, at least admit to me, that if she's still married to her husband, that it should be returned to the woman. The lav bas bironi, because if she's still married, it clearly wasn't paid yet. But the Rabbanan say no, that's not necessarily the case. Maybe it was paid, and the husband gave her like a collection of money in place of the bond, and that was put in a specific place. Ravina gives a different approach. Ravina says, no, go back to the first price, so where we say the Rabbi Yossi says. We had said Rabbi Yossi says that that if you find the contract that's certified, you could collect it, and the Rabbanan say you can't. Now we reverse those positions. Rabbi Yossi says you can't, and the Rabbanan says you can. The time of the Rabbanan hachas. So if that's the case, if the Rabbanan say that you can collect it, then if that's the case, what's the reason why the rabbis say in the case of the ksuba you can't collect it, because mishum dechashin l'shtei ksubos. We're worried that somehow or other he had to write her two ksubos. Why? Let's say she lost the first one, and so he had to write her a second. Rabbi Yossi says you can't collect it. It says l'shtei ksubos l'chayesh. We don't have to be concerned that he wrote her two ksubos. Why would he write her two ksubos? Either she lost it, or else maybe he wanted to, he gained a lot of money. So for her anniversary present, he gave her an extra ksuba. I'm a Rabbi Elazar, so now Rabbi Elazar taught machlokas. Now, the word machlokas here doesn't mean an argument. It means the division when we split the shnayim ochsa b'talos. When we split the two taloses, this division is b'sheshneim adukim b'tofes. When do we say we split the contract? That if one person's holding one side of the contract and one person's holding the other side, when both of them are holding the tofes, ushneim b'toref. What's the tofes and what's the toref? The toref is the part of the contract that contains the personal elements, the date, the names, the place. Whereas the tofes is the template of the contract. There are two parts to a contract. One is it starts with the names of the lender and the borrower, and that's called and the amount of money and the loan and the date. That's called the toref. And after that, you put the legalese, which is the tofes. But also at the end of the tofes, you put back the toref, except for the date. You put everything in except for the date. And the witnesses sign at the bottom, underneath the tofes. So you start with the toref, and then you do the tofes, which is the template. But in the tofes, you include everything except for the date again. So Rabbi Elazar says, when do we divide up this contract that they both collect? When both of them are holding the tofes or both of them the toref. But if one of them is holding the tofes and one of them is holding the toref, one's holding the template, one's holding the toref, the personal element, zenotal tofes for zenotal toref. Then this one just takes the tofes part of the contract. The other one just takes the toref. So Rabbi Yochanan Amar Olam Cholkin. Rabbi Yochanan says, no, you always split it. Even if one is holding the aduk and one is holding the toref. Gemara says, first, we challenge Rav Yochanan. I don't understand. V'atanya, but it says in the Brisa, the Gemara says, how could it be? How could Rabbi Yochanan said even if one is holding the tofes, one is holding the toref, that you split it? V'atanya, that each one holds until the part where their hand reaches. So the Gemara says, no. When does Rabbi Yochanan say that you split it when the tarf is in the middle? So the Gemara says, well, if that's the case, that we're talking about a case that neither one is holding the tarf, what's the chiddush here? So the Gemara says, no, that the tarf is closer to one, just like the case of the gold before. He might have said that you could split it here, Kamash Mulan. No, you split it in a way that they each get to share from the Torah. So I'm Rav Achmi Diftel or Ravina. So he says, according to Rabbi Elazar, says this one takes a tofes and this one takes a toref. Well, I don't understand. What are you going to do with half a contract? So they use the contract as a cork. But I mean, is that what we're arguing about here? You're going to get this note which says you owe $1 million, and they're arguing about, since they're not getting the complete contract, they're going to basically use it as a cork. Is that what they're arguing? He says, no, he wants to use it for the value. The Amar Hachi. So he says, because he basically says as follows. How do we evaluate it? Shtar the Isbeizman Kama Shavi, a contract that has a date in it, how much it's worth, because the tofes at the end does not have the date. With the late Beizman Kama Shavi, and if it doesn't have the date, how much is it worth? Bishtar the Beizman Gabim Mishavdi. So there's a difference, because if the contract has a date in it, you could collect from the properties that there's a lien on it from the time of the contract, from the date, v'idach. But if it has no date, Gavim Mishavdi. And so therefore, since there's no date, you can't get the lien property. The one who holds the tofes gives to the one who holds the toref the difference between the value of the contract if it has a lien on his properties versus not. So, okay, we'll stop here. and pick this up, God willing, tomorrow's daf. If anybody has any questions, happy to address.